77. Mr. Kramer, good morning.
Good morning, Your Honor, and may it please the Court. This morning I have the privilege of representing a young lawyer whose quest for experience ended in a bad experience for her and for her client. And despite the best of intentions, Sudha Narasimhan still regrets the mistakes that were made in the underlying case, perhaps even more now with the benefit of experience that she's gained in immigration law under the tutelage of a very fine mentor. But her mistakes reflect a lack of experience rather than a lack of character. And for that reason, Your Honor, I cannot agree with the sanction proposed by Bar Counsel today. Though the quality of representation was certainly lacking, I wish to make three key points today. First, that throughout the underlying case, Sudha displayed a dedication to client service as documented by emails and calls responsive to client needs. Two, that she did not embellish credentials for the sake of a job. And three, did not commit any willful act of fraud or deceit meriting a suspension from the practice of law, particularly in light of several mitigating factors that we may discuss today. One thing we have not quarreled with is competence. It's true that Sudha placed her faith in a lawyer whose expertise did not match his seniority. But we're not using that as an excuse today. Sudha recognizes her responsibility as a member of the bar, independent of anyone that she may work for or with. And it's hard to quarrel in hindsight that perhaps she should have more thoroughly vetted this attorney. Yes, he had 16 years of experience. She did verify that he was a member of the Arkansas Bar in good standing and assisted him in about 5 public seminars on immigration and naturalization process. So she thought that she was dealing with someone who had the bona fides to work this case. And I guess it's debatable whether a junior attorney, someone without experience, could really vet the experience of someone far more senior, but that's not a debate that we wish to engage in here. The violation of Rule 1.1 is established because ultimately the client did not receive the quality of representation that my client had hoped for and intended.
Counsel, the contention is that your client misrepresented her qualifications and her experience for personal gain, or for personal and financial gain. Did that happen? Did it not happen?
It did not happen.
All right. Why do you say it didn't happen?
Because Sudha never claimed to be qualified for the job. If you'll recall, the request for proposal submitted by D.C. government sought an attorney with at least 5 years of relevant experience. If Sudha Narasimhan wanted to get the job and embellish her credentials to do it, she would have said, I've got more than 5 years of experience in immigration. She didn't. In fact, the MPD knew from what she submitted that she was not qualified for the job. What she did was to emphasize the credentials of a lawyer that was 16 years her senior.
Then are you saying there were no misrepresentations contained in that resume that's been talked about?
There were misstatements, and let's be clear about what misstatements we're talking about. There was an indication in the resume that she handled family petitions and citizenship applications prior to submitting the ILG proposal. And in fact, she had reviewed 2 N-400 citizenship applications, but she reviewed them before the ILG was actually formed, and it's listed in the resume under the ILG. And secondly, rather than handling multiple family petitions, she handled one, an application to register permanent residence or adjust status, the I-485 form, and that was done under the auspices of the ILG in September of 2009. Now, what is a misstatement about that is that she says family petitions, plural, when it should have been singular, and the citizenship applications were reviewed for friends prior to the ILG. But is that a false misrepresentation of material fact? And I would contend that it is not. It's interesting because when you take a microscope to a resume, it's difficult to know whether anyone's resume will really pass muster. Under a microscope, small lizards look like dinosaurs. But that's not what we have in this case.
Well, Mr. Kramer, go ahead. Mr. Kramer, I seem to recall some references in the papers that we have before us that maybe it was her representation to Bar Council or maybe her testimony at the hearing before the hearing judge, where her resume included what she anticipated prospective experience as opposed to experience, as I understand the word.
Well, if one looks at the resume, which is at tab 5, Your Honor, under the immigration law group, the first thing that's said on the first line of the description is representation of immigration clients in documentary immigration processes and litigation. And then it says, in the past tense, handled family petitions and citizenship applications. If you contrast that with the way the rest of the resume reads, what my client intended was to indicate what the ILG was formed to do, which by the joint venture agreement is confirmed that that's one of the those are the things the ILG was formed to do. Now, I understand a casual observer could say, well, that's a misstatement. Is it a material misstatement? I don't believe so, Your Honor, and the reason is that, for one thing, this didn't even involve litigation. There was no indication that litigation would be necessary in this case in any way, shape, or form.
Wasn't that inclusion on the resume material in connection with what the police department was seeking to find in terms of the expertise of an immigration attorney?
No, it wasn't. And the reason it wasn't is that Ms. Narasimhan did not have in any way, shape, or form the qualifications to fill out that request for proposal. She didn't have it. Because that required at least 5 years of relevant experience. In fact, as Director Haynes for the MPD testified, neither she nor Mr. Rogers independently had the qualifications, because while Mr. Rogers had the experience, he wasn't a member of the Maryland, D.C., or Virginia bar. And ultimately, Director Haynes, having only gotten one submission in response to the request for proposal, spoke to Mr. Rogers, and Mr. Rogers convinced Director Haynes.
Was it a requirement that there be a membership in Maryland bar?
Maryland, D.C., or Virginia was the requirement.
And he was none of those?
He was not. But what he did was he spoke to Director Haynes, and he convinced Director Haynes, as Director Haynes testified, both in deposition and at trial, that it wasn't necessary because in immigration matters, it's largely a federal practice. And she was satisfied with that. So what they decided to do was to give them the contract anyway, even though under the strictures of the original RFP, neither would have qualified. But you see, Your Honor, if in fact SUDA was trying to embellish credentials for the sake of getting a job, it's hard to understand why, when D.C. government said, well, wait a second, the lawyer listed as the D.C. contact has less than 3 months' experience in immigration matters. What do you have to say about that?
Was that the only misstatement on her resume?
The family petitions and citizenship applications, that was technically inaccurate. But she did, in fact, handle a family petition and did review citizenship applications.
Mr. Kramer, the judge also found that she had misrepresented. Let's see. As of the submission date to MPD, the respondent had not represented multiple clients in documentary immigration processes, nor had she represented any client in immigration litigation. Are you saying, just so I understand, as a result of the colloquy between you and the Chief Judge and you and Judge Atkins, as well as Judge Green, that she did not make any misrepresentations so the court's findings were clear error? Or are you accepting the court's findings and saying that the misrepresentations were not material?
Well,
this is an either or. Were the findings of the hearing judge clear error?
Your Honor, I have to answer it this way. The judge was correct that she hadn't represented multiple clients in connection with the family petitions because she had handled one, not plural. That's number one. I believe that's an immaterial inaccuracy.
Then it goes, it's not to the clear error and the trial and the hearing judge. It's to the materiality under Rule 7.1. Correct.
Exactly.
Okay.
Exactly. Because the fact that there's inaccuracy, I can't stand before you and tell you there weren't inaccuracies. There were. The question is whether these were material inaccuracies motivated by a desire to get the job. Now, the judge said to me, well, I'm just applying pure logic. Pure logic tells me that, yeah, she's a young lawyer, she wants to get the job. But that's not logical when you realize that she never had a prayer on her own of getting the job, and she never made any bones about that. And the MPD confirmed that she never tried to misrepresent that she was qualified to get the job herself. That's why.
Was she being paid in accordance with how much work was brought into the firm in Maryland?
She received, in this case, half of an $1,800 fee, which was $900. The bid was a pretty low bid, surprisingly low perhaps, but that's what she received.
Do you agree that the 1.3 and 1.4 rule violations are established?
No, I don't. I do believe they're established in one sense I do, in the sense that the quality of representation wasn't there. But when it comes to the responsiveness and dedication to customer service, that's something that the MPD, Director Haynes herself said she found Suda exhibited throughout the course of representation. She was very responsive to client communications. And one thing that I do believe was clearly erroneous is this contention by the judge that she was largely unavailable during her trip to India. That's not a matter of credibility determination. That's a matter of reading comprehension. She informed the MPD up front of her planned trip to India, even before the representation commenced. That's what Director Haynes told us. And while she was away, she continued to communicate with the MPD. She sent 7 emails on this case, which are at tabs 21 through 29, 4 of which were directed to the MPD. And although she had some communication problems with the telephone and couldn't participate in a December conference call, right afterwards she emailed Mr. Rogers and said, hey, I'd like to know what the developments were. Those aren't the actions of someone who was largely unavailable. The record confirms that she was quite responsive. And there weren't any emails to which she didn't respond. So in that sense, I do disagree with one of the findings. And although that doesn't necessarily get me out of Rule 1.3 and 1.4 trouble, what I think it does do is help put in perspective that this was not a lawyer who was out there totally neglecting her clients, who could care less. That seems to be the implication of a bar counsel that wants to make this thing seem so much more sinister. It isn't. Diligence was only a problem insofar as competence was a problem. But when it comes to communication and responsiveness, the 1.4, there I do disagree with a violation. I don't think there was such a violation in this case. We're talking about an attorney when asked, well, what about your inexperience? She didn't try to bolster her experience. She didn't try, I got to get this job, so I need to say, hey, well, in the limited time I've had, I've done all the stuff. No, what she says is she didn't have any current clients in D.C., had not, in all caps, filed any papers on behalf of the government. She defers to the expertise of a more experienced attorney and expressed the desire to learn from that experience. Those are not the words of a lawyer seeking to embellish her credentials for the sake of a job. What did she do? And if you look at the totality of communications, and I think that it's important to do that, so that we not take a microscope to the lizard, but rather take a look in context, which is what I think 7.1 requires. She emphasized her personal experience, with the immigration process. She thought she had a good knowledge of immigration laws in this country and could empathize with the situation of U.S. immigrants. And that's not a misrepresentation. In hindsight, we can certainly say her knowledge of immigration laws was quite lacking. But as the Bar Counsel's expert himself testified, Suda didn't know what she didn't know. She was not aware of how big the universe of immigration law was. So though she may have thought, in good faith, that she had a good working knowledge, in point of fact, she did not. But that's not the type of thing that I think we can say under 7.1 was a misrepresentation. The resume showed largely unrelated experience and not much experience at that. And while it's true that maybe some citizenship applications were reviewed for friends prior to the formation of the ILG, when exactly she reviewed those, or whether there were multiple family petitions or just one, is kind of beside the point. Bottom line is, she did not, on her own, have the ability to get that job. She did what Rule 1.1, Comment 2 encourages. She affiliated with a lawyer that she thought had established competence. In point of fact, we know that was not ultimately the case, as we all learned painfully.
Could you refresh or explain what her due diligence was to determine whether Mr. Rogers was sufficiently experienced in the area where she wasn't?
She met with him many times, actually, before the ILG was formed. He had traveled frequently into the D.C., Maryland area for purposes of meeting with clients. He certainly talked a good game. She contacted the Arkansas Bar to verify that he was a member in good standing. She assisted him in public seminars held at the local library and some senior groups and others on the subject of immigration law. So she was able to see him in action, espousing what she believed to be his expertise in the area. And I think, therefore, she felt she had a pretty good handle on this fellow who looked to be the kind of mentor she was seeking.
But you said that she didn't know what she didn't know.
That's right.
And wouldn't you think it would be more rational to vet Mr. Rogers with someone else or some government entity about his experience instead of just listening to someone blather on about something? It's like the cartoon of the dog listening to his master. All you hear is blah, 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 blah.
Well, it's fitting. It's Monday morning, and if you're a Monday morning quarterback, you can definitely say that, yes, in hindsight, it certainly would have been very helpful to do more investigation. But I would say, Your Honor, that when you're an inexperienced attorney and you've got somebody with 16 years of experience who seems to have the knowledge, and you've seen them in action talking about the subject matter with others and preparing materials and the like, that how skeptical must we be? Well, obviously, this case, in hindsight, proves that we need to be more skeptical. But I'm not sure that's a mortal sin here. Unfortunately, it would have been nice, and if we knew then what we know now, we certainly would have done things very differently.
Mr. Kramer, you mentioned that there was a conversation, or at least communication, between Rogers and the police department. What was the nature of the contract? Well, did it include terms that he would be the one who would be managing this immigration matter, or that your client would be? What?
Director Haynes said it. Yes, and Director Haynes said it best in her testimony, that Mr. Rogers was the person providing the legal advice to the MPD, and Suda was going to be the local liaison to Mr. Rogers.
Okay, and what did happen?
Well, that's actually what did happen.
But what did happen following? Is there evidence in this record, or at least findings of fact by the judge, that your client did, that everything went as contemplated? That Mr. Rogers was the lawman and she was simply the conduit?
Well, that actually is what the documents in this case show, that in fact she was largely the conduit. She did have to step up her game when things fell apart in May and they got a denial of the labor certification. I mean, I think that's the first time that it really occurred to her that maybe she wasn't dealing with someone who knew everything that he was supposed to know. Unfortunately, things did fall apart by then. Your Honor, I know that you're going to hear in a moment from Bar Counsel about sanctions. There were no aggravating factors in this case, and many mitigating factors, which we can discuss in rebuttal. But I believe in this case, Your Honor, we're dealing with an attorney who, as the lower court indicated, got in over her head with an attorney whose credentials perhaps she could have done a better job vetting. But we're not dealing...
Before you sit down, I'm just looking at the finding by the court that the record is filled with numerous incidents where Dr. Samuel and or Director Haynes had difficulty communicating with the respondent. You referred to the time when she was in Pakistan.
India, yes.
Sorry.
It's okay.
Are there other times in the record that the court may have been referring to?
The only thing that the judge mentions in his fact pattern is that one of the planned conference calls never happened, but we don't know why. That was apparently a late December or January conference call, and there was never testimony that it was my client's fault or anyone's fault as to why it didn't happen. It just didn't happen. The other thing was...
Yeah, but he does say the respondent also did not respond to Dr. Samuel and Director Haynes' multiple requests for information regarding an extension of Dr. Samuel's current visa. The representation was eventually terminated in part because of the difficulties the MPD had communicating with the respondent. So there was a...
And, Your Honor, that's simply untrue. And it's untrue because when that inquiry was made by Dr. Samuel...
It was a clear error.
Yes.
Okay.
Clear error because you can read the email. It goes from Dr. Samuel to Sudha Narasimhan. Immediately, Sudha Narasimhan turns around, forwards that to the client, forwards that to Mr. Rogers, asking Mr. Rogers to respond ASAP, because Mr. Rogers knew the answer to this.
I know,
she did not.
But she did not respond to the client.
Yes, she did, actually. The client, or I should say the complainant, Dr. Samuel, technically not the client but the beneficiary, said, oh, no, she never responded to me. In fact, we produced the email in which she did respond to her right away.
And what did she say?
She said that Mr. Rogers will be getting back with you as soon as possible. I mean, it's not that she totally neglected this. And as far as the...
Exhibit is that?
That...
We don't have all those emails in front of us. They're in the record.
I know that would actually, Your Honor, probably be about tab 29. I'll make sure I get that for you. But the fact is that she turned it around really quick. As far as the later communication, before they could even respond in terms of future appeal processes and the like, they were terminated. Thank you.
Okay, we will let you know, Mr. Kramer, how much time you have remaining in rebuttal when you stand back up. Ms. Lawless.
May it please the Court, Lydia Lawless, Assistant Bar Counsel on behalf of Petitioner. Before I begin, or I guess to begin, the record is clear that Mr. Rogers did not supervise the respondent in this matter. And I would look no further than the respondent's own response to Bar Counsel, which was tab 72 to Petitioner's exhibits, where she specifically states, I handled the representation. She states, I sent a detailed email of the labor certification process. I, in conjunction with Mr. Rogers, worked with Dr. Samuel to complete the initial form. Nowhere does she state that she was supervised by Mr. Rogers. This reliance on comment 2 to 1.1 developed very late in the procedural posture of this case and is not supported by the facts. It's not supported.
What about this email that we were just discussing, indicating that she referred the question to Mr. Rogers, is it?
Yes. Yes, sir.
And said he would be answering it.
Yes, Your Honor. That is one instance where she did refer or defer, I guess I should say, to Mr. Rogers. But the record is replete with evidence and examples of the respondent giving advice directly to the Metropolitan Police Department without first running it by Mr. Rogers.
Can you give us examples or specifics of what type of advice she gave without his expertise?
Yes, specifically at the same day that the contract for legal services was received, which was November 30th, the respondent sent an email to Metropolitan Police Department to Director Haynes. In that email, she purports to outline what the labor certification process is. The record contains her then forwarding that email to Mr. Rogers, basically saying, look, I've gotten the ball rolling on this. I've given the client advice. Mr. Rogers responds in kind, or to that email, saying, thank you, good job, clearly showing that he didn't draft that email. He did not provide that advice. As it turns out, that advice in that email of November 30th was based on the old labor certification process. It was old advice and no longer, or the labor condition application process that was outdated and not current. So it turned out to be bad advice that was given, but clearly that was given by the respondent of her own accord, not in reliance on Mr. Rogers, and it was not run by Mr. Rogers.
That gets you to incompetence, perhaps.
Correct.
Does it really get you to the conclusion that he was not supervising her?
Yes, and I would also look at the joint venture agreement between Mr. Rogers and the respondent, where it says that they share equally. It further states, and I believe Judge Johnson...
Share equally in what? In the workload, in the compensation?
In the compensation and in the responsibilities to the joint venture. I believe Judge Johnson made specific findings that in the joint venture agreement, it states, and I'm looking at page 8 of the findings at the bottom of the page, that the respondent was named as the attorney primarily responsible for the practice of law and for the clients of the joint venture. And now if you'll look, and I believe that the respondent states in the exceptions and recommendations that Mr. Rogers was to provide legal advice, if you read the joint venture agreement and read that sentence in context, it's legal advice to the joint venture. And it was clear in the agreement between the respondent and Mr. Rogers that she was primarily responsible for the clients, for representing clients, for providing advice, and for the practice of law.
Well, go ahead.
Do we know who drafted that?
The respondent drafted that agreement.
Are you contending that she wasn't signing on with him in order to have him be her mentor and for her to learn from him?
I believe that was her intent, yes. But I believe that if you look at the...
I'm sorry, I'm having a little trouble.
I believe that was her intent, that she was looking for a mentor. I don't think that is a misstatement. And I believe sincerely...
What did the hearing judge have to say on that subject?
That she was looking for a mentor?
Well, yes, because, you prosecuted this matter, but we looked at what the judge found.
Well, the judge
did the judge
found
speak to this one way or the other?
The judge found that her reliance on Mr. Rogers as a mentor was not reasonable. And to get to Judge Harrell's question to Mr. Kramer, she didn't review his CV. She didn't ask for references or check references. She didn't do a Westlaw case search to see who or what he had ever represented. She didn't check him out on PACER. She didn't do anything, essentially, to vet him besides calling the Arkansas bar and verifying that he was an attorney in good standing.
Did the hearing judge make these specific findings that you're citing or relying on about her lack of vetting Mr. Rogers?
He did not make those specific findings, but they're not disputed. The respondent testified to that, both at her deposition, which is part of the record as Petitioner's Exhibit 2, and I believe I cross-examined her on that as well, but I'm not positive. But those facts are not in dispute as to what she did and did not do to vet Mr. Rogers. So when you're looking at the representation and two attorneys are representing a client, they are equally responsible for that representation.
I'm just thinking...
Yes, Your Honor.
I'm just thinking about the experiences I've had with young lawyers, fresh out of law school, looking for a job. They don't have the same mechanisms, I'll say, thought processes that someone might have who'd been out in the world practicing law or doing something else even for 10 years. In other words, don't we have to give them a break in a decision as to how much to vet somebody?
I suppose so, but I would suppose also that it would be petitioner's position that a minimum reasonable of any person would be to look at a CV and to call a reference. I would also submit that the respondent, while she was a newer attorney, she did not go directly from undergraduate to law school to the practice of law, that she had been employed and she was a little bit more experienced in life and was a professional before attending law school.
What did she do?
I cannot recall. I believe she was involved in web development, but
how many years?
I'm not positive. I can't recall that fact off the top of my head, but I know that
She's been a member of the bar since June of 2007, so not woefully inexperienced, I suspect.
yes, Your Honor, and I think at a minimum, when anyone applies for any job, they submit a CV or a resume and references. And at a minimum, the new members of the bar, if they're going to team up with who they contend are more experienced attorneys, have an obligation and a duty, I think, to do basic due diligence.
What was the judge's take on the resume? And you've heard from Mr. Kramer. How does all that, how would you present on the resume? Do we just have a little bit of puffery here or something more? And I guess another way to put it, were the judge's findings with regard to the resume, to the extent that he made findings, are they supported in the record?
Yes, they're supported in the record, and that's based on the respondent's own testimony when I confronted her with it at deposition as well as on cross-examination.
And could you catalog those misrepresentations as you understand them?
I think that they were as Mr. Kramer cataloged them, which is that she had no litigation experience, no immigration litigation experience, that the family petitions that she had not handled. It was not in the context of an attorney-client relationship, that she was reviewing a petition for a friend of hers before it was submitted to whatever agency it was submitted to, and that there was one documentary case, and in her deposition, when I questioned her about it, her statement was that she wasn't involved in that, and that all she did was mail the form, that Mr. Rogers handled the entirety of the representation, and that she basically acted as an assistant to him, not in a legal sense, more in a paralegal sense, in completing and mailing a form.
So you're talking about her friend?
No, the one case that was handled by the
Okay.
Immigration Law Group, the documentary immigration case that's reflected on the resume, in actuality, while the respondent may have assisted Mr. Rogers in that case, she did not handle the case. Her appearance, a G-28 was not filed, her appearance was not entered, and when I questioned her as to the specific involvement, her specific involvement in that case, it turns out that all she did was complete and mail the form, that she wasn't actually involved in the handling and the actual representation of that matter. All of those things are misrepresentations, and the materiality of those misrepresentations are certainly relevant for 7.1, and it's petitioner's position that the court's conclusions were supported by the evidence and that these are material misrepresentations. Could they have been worse? Sure. Could she have stated that she had 5 years of immigration experience to try and get the bid on her own? Sure. It could have been worse. There's no question about that. But as Mr. Kramer concedes, they were misstatements. The Metropolitan Police Department was certainly concerned about her experience because there's the follow-up emails where they say the local attorney has less than 3 months of immigration experience. The respondent then repeats the misrepresentations and goes on to say that she is well-versed in immigration law. Judge Johnson found that additionally was a material misrepresentation.
Ms. Lawless, one of the themes in this case is that the hearing judge made findings, for example, about multiple misrepresentations, a failure to vet, a failure to be responsive, but the document that the hearing judge produced doesn't give us the specific examples of the misrepresentations, the failure to vet, how she didn't respond. How do we factor that into whether or not to sustain or find the violations the hearing judge found And is this a case that should perhaps be returned to the hearing judge for more specific findings?
The judge makes specific findings about the misrepresentations, not under the section of 7.1, but in the findings of fact. Specifically at page 3, the middle paragraph there, the respondent stated in her submitted resume that she had represented, quote, immigration clients in documentary immigration processes and litigation, and that she had handled family petitions and citizenship application. The court finds that the respondent's resume contains several misrepresentations. So I believe that when, in reference to 7.1, that it's those facts that the hearing judge is relying on, and the finding of an 8.4C violation as well. And as your other question, I believe, was to the vetting of Mr. Rogers. And as I stated before, that wasn't in dispute, and it wasn't in dispute at trial. And the record clearly reflects the respondent admitted what she did and did not do as to vet Mr. Rogers. So similarly, I don't think that any additional evidence or additional findings could or should be made on that matter.
What was the police department's understanding of the degree to which respondent was going to be handling the matter, the immigration matter?
It's my understanding that the respondent stated that Mr. Rogers would be supervising her, and we have that in writing in response to questions about her inexperience.
Is your understanding that it was the police department's understanding that that's how it would go? Do we have anything more solid than that?
One of the things that's interesting about this case, and the respondent relies heavily on the testimony of Director Haynes. Director Haynes is the director of human resources for the Metropolitan Police Department. Dr. Samuel was the beneficiary of the petition or the visa application that was to be filed. And what ended up happening, and the evidence in this case is pretty clear, that once the bid was submitted and the immigration law group was retained, Director Haynes really turned the case over to Dr. Samuel. And it was Dr. Samuel and the respondent who were primarily communicating. So it was Dr. Samuel's testimony that she relied and went to the respondent when she had questions or concerns, and that the respondent oftentimes immediately responded to those questions and concerns, supporting petitioner's contention that she was not actually supervised by Mr. Rogers. So while Director Haynes...
Before she sent the document to be filed, did she have Mr. Rogers, yes, review it? Did she have him review it?
It's questionable. There were multiple drafts of this form that were prepared, and they were circulated amongst Mr. Rogers, Dr. Samuel, and the respondent. They were all participating in compiling the information, editing it, and what we have and what's in evidence is that it was really Dr. Samuel herself who was reviewing the work before it was submitted.
Well, did the hearing judge make a finding on that point?
No, Your Honor. The hearing judge did not.
So we don't know whether her work was reviewed by her joint venture partner.
That is correct, Your Honor.
Our counsel has recommended an indefinite suspension and has recognized that there's really no case available upon which you rely to make that recommendation.
Yes, Your Honor.
Okay. So, taking into consideration that the judge did not make any finding of fraud, which he specifically, says, what do you see warrants an indefinite suspension? And the second part of the question is, because an indefinite suspension is such without a limited period of time, the respondent, if she were indefinitely suspended, could come back tomorrow and reapply. What would be the conditions that would render, from Bar Counsel's viewpoint, her eligible for reinstatement?
Okay. To the first part of your question, this case was never charged or tried as a fraud case. And in my closing argument at trial, I said, when you look at 8.4C, there are the 4 elements, and this is not a case of fraud. And I would point the court to Dorr, where recently there was discussion about misrepresentations in 8.4C, and it's not a specific intent. Additionally, it's not charged as a fraud case because it's not disputed that the Metropolitan Police Department didn't really rely on these misrepresentations. You know, the respondent keeps saying they didn't rely on it. They knew she was inexperienced, and all of that is true. There was no reliance, so you sort of don't get to the fraud element of it. What we do have are admitted misstatements on a resume to get employment for the respondent's financial gain. What you have following that is basically a complete failure to comport and comply with the standards of the profession. And we struggled with making the recommendation of an indefinite suspension. We certainly did, and part of the reason we made the recommendation is to ask for some guidance from the court, essentially. And we look at an indefinite suspension as we look at the Keppel case and the Floyd case. And I think this case is distinguished from both of them in that it's worse in that there's a client matter. There's actual harm, actual damage, and both of those cases had substantial mitigating factors that don't exist here. So I think when you have the 8.4C, you have the lack of mitigation, everything other than her relative inexperience at the bar, and you have what petitioner has claimed to be aggravating factors, I think you reasonably get to a straight indefinite suspension because it goes to the respondent's character, her truthfulness, and the like.
I'm looking at a statement on page 8 of the respondent's exceptions and recommendation for sanction, and I'll read it to you. Although the respondent was unable to join the conference call in December, Director Haynes did not find it necessary to have Suja on the call because the advice that she was taking she wanted from Mr. Rogers. Do you disagree with that statement? Is that not factually supported?
No, I don't disagree with that statement, Your Honor. But as I said before, if you look at the actual case and the way this developed, the communications were from Dr. Samuel to the respondent. And Director Haynes she would just come in on occasion to be involved in the representation. But when you look at who is actually communicating, it's Dr. Samuel on the one hand and the respondent on the other hand. And Dr. Samuel, on behalf of the Metropolitan Police Department, is over and over and over again deferring to the respondent and relying on the advice that the respondent is providing.
Who was the client?
The client was the Metropolitan Police Department, and this is one of the issues that goes to the competence and the diligence and the communications in this case, because it was never made clear to the Metropolitan Police Department that Dr. Samuel should not have been involved in this representation at all as the beneficiary of the visa application.
So when Director Haynes testifies as to what her understanding of who she wanted the advice from, that would be more important than any testimony by, and I'm sorry, I'm not doing well with the parties' names, but any testimony.
Dr. Samuel?
Yes, Dr. Samuels, thank you.
On one hand, yes. On the other hand, no, because the evidence is also undisputed that Director Haynes deferred the matter to Dr. Samuel and gave permission for the respondent to communicate directly with Dr. Samuel. So Director Haynes didn't distinguish between herself and Dr. Samuel either. No one understood that there were two, that the Metropolitan Police Department and the beneficiary were not one and the same client being represented by the same attorney because they had a common interest at that time. So yes and no, Your Honor.
Can we get back to the
Yes.
second part of my question?
Absolutely. Your second question
Which
would
is the
be
condition issue.
the conditions of readmission. And that is why we requested an indefinite suspension, because of the safeguards that are built into the Maryland rules. We were not requesting any additional requirements for the respondent to come back into the bar off of an indefinite suspension. But I think it is important to know where the respondent is, what she's doing, what her current financial status is, and the other safeguards and the other things that are required for readmission off of an indefinite suspension. And that's part of what went into our consideration in recommending to the court that the respondent be indefinitely suspended.
There's in the indefinite suspension rules, having had a recent not familiarity, because I'm certainly familiar with them, but reviewing them, there's a lot about financial aspects, in reinstatement. It seems to me that some of the questions have gone to her basic, the respondent's basic familiarity with the law. I mean, are we talking about remediation in terms of courses? I mean, I'm interested also in the mentorship aspect, of course. And I'll just put in a plug for the Court of Appeals mentorship program for the newly admitted right here, but because I do think it's important. But are we talking about some type of mentorship condition, or, because these issues are very difficult for new lawyers.
Right. It's my understanding, and it was the respondent's testimony at trial, that since the end of the joint venture agreement that she has, in fact, been employed by who is accepted in the immigration community of attorneys to be a highly regarded immigration attorney, and she has used, to some extent, the benefit of what she's gained to reflect on the representation of the Metropolitan Police Department. The reinstatement rules address how a respondent has kept up with law and the rest. And for Bar Counsel, I think that it would be our position that, given what we already know about this respondent and where she's gone since this representation, in the experience that she has obtained there, combined with what I assume would be additional things she would do during the course of a suspension in this matter, to stay abreast of immigration law, if it is immigration law that she continues to practice, I think that built into the rules is sufficient safeguards for the bar and for the public.
Well, we don't usually get into that in these cases, but it is interesting.
Mm-hmm.
Do I hear you say that, let's say we went along with an indefinite suspension. If the respondent were to apply for readmission on the first possible day and offered in the petition for reinstatement the information that is itemized in the rule, Bar Counsel won't be in here saying, in my answer, she just hasn't sat out long enough for the gravity of the offenses which she was found to have committed.
I think that if the court is inclined to issue an indefinite suspension with a right to reapply at some time, the minimum would have to be 90 days, because I think that is in a line with Floyd. And I think when you look at Keppel, I believe the court said that but for the mitigation, this would have been a straight indefinite suspension. Or perhaps that was in Dorr. I think in Keppel it said but for the mitigation, it would be a disbarment case. I think that the jurisprudence in this case, that when respondents apply on the first day after an indefinite suspension, no one is prepared to readmit them. So, yes, I think when you look at the case law and when you look at the additional factors in addition to the misrepresentations, that there is some minimum time that the respondent would have to sit out. And we don't know exactly what that minimum time is, which is why we requested a indefinite suspension. I suppose if the respondent applied on the first day after sitting out, we would look at what was contained in the petition and consider that with all of the facts that we've learned during the investigation and prosecution of this matter and make a recommendation to the bar at that time. But it would certainly be Bar Counsel's position that a minimum, absolute minimum, based on the record and the findings in this case, would be an indefinite suspension with a right to reapply in 90 days.
What would be the material differences between what the respondent would have to demonstrate to be readmitted if it was indefinite suspension with right to reapply no sooner than 90 days and or a flat 90-day suspension?
The reinstatement rule, the requirements of 16781, that they don't apply if it's a straight 90-day. There's the shortened reinstatement provision. And I think that to go to Chief Judge Barbera and Judge Battaglia's questions, that this issue of how young attorneys are keeping up with the practice of law is important, and I think that those safeguards are built into the rule. I would also say that this case, and Bar Counsel has always taken the position that this case is an important case because it involves a young attorney starting out on her own, has difficulty finding employment, hangs out a shingle, attempts to affiliate herself with who she believes to be a more experienced member of the bar. And I think that it's important and Bar Counsel thinks it's important for the court to provide some statement to the bar about what is expected, because it has to be more than what was done here. And petitioner would recommend that the court overrule the exceptions filed by the respondent and indefinitely suspend the respondent from the practice of law. Thank you.
Thank you, Ms. Lawless. Mr. Kramer? Mr. Cockrell, how much time does 6 minutes?
Your Honor, one thing that the circuit court did find is that Suda is a person who, in fact, does want to be a good lawyer, but simply got in over her head. I don't believe that this is a case meriting a suspension, and certainly not an indefinite suspension. And here is why. First,
Your recommendation is a public reprimand. Is that correct?
That's correct. And the reason...
As a sanction, what do you think that says about our protection of the public?
Well...
Because that's ultimately the basis for our sanctions. So how does that go together with protecting the public?
For one thing, Your Honor, there is no doubt in my mind that this is a situation that is not at all likely to be repeated in the future. Since the time of the facts that underlie this case occurred, my client, and this to answer your question, has worked under Farhad Ahmed, as Bar Counsel indicates, a very highly respected immigration attorney in the state of Maryland, has been getting amazing training. It's a shame she didn't have her as a mentor for this particular case, because she's been getting outstanding training in the field of immigration law. So much so that during her deposition, she was able to go through all the paperwork and identify all the various mistakes that were made. There was never any bones about that. Judge Johnson even remarked about her complete candor repeatedly to the court. And her cooperation in this proceeding is beyond dispute. This is not, it would be true, maybe meriting a suspension if, in fact, she tried to embellish credentials for the sake of getting a job. But that's not what happened here. Because, Your Honor, a misstatement does not mean it's fraud and deceit. This is very much unlike Keppel and Floyd. In Keppel and Floyd, we were dealing with fraud cases. We were dealing with misrepresentations in one case, in Christine Keppel's case, to a law school for purposes of getting in-state tuition. Greed at the heart of that.
Our counsel has said we never prosecuted this case as a fraud case.
Right, but she's saying
That's
that
off the table.
She's saying this case is more serious than Keppel or Floyd. It isn't more serious than Keppel and Floyd. It's far less. There are mitigating...
She said specifically that Keppel had a lot of mitigation in it. There were findings of mitigation in Keppel that were beyond any findings in this case, or many findings in many cases, because there were domestic issues that were involved in that. So, I mean, there's been a recognition that those cases are an opposite. But the question that I'm asking is, how does a public reprimand fit here? In terms of, under your rationale, there really should be no sanction because she has a job that she's learning from.
A reprimand says, lawyers, you need to be more careful. Even new lawyers, you need to be more careful about who you associate with. This is a scenario that doesn't involve a lack of character for which a suspension would be required. This is a situation where the mistakes that were made reflect a lack of experience and not a lack of character.
Well, the misrepresentations, although albeit not fraud, are still misrepresentations.
I think
and
they're
you're
more...
not quibbling about the misrepresentations, you're quibbling about their materiality.
I'm quibbling about how big a deal it is.
Yeah,
I am
that's
absolutely materiality, but also, this is not a scenario where you've got outright resume fraud. The one case in Maryland, there actually isn't a reported case in Maryland dealing with resume fraud, that dealt with a fellow who said he was graduated first in his class and all these other wonderful things, Phi Beta Kappa and the like, resulted back in the mid-'80s in a private reprimand. The D.C. bar imposed a public reprimand. But in this case, a suspension says, we've really got to excoriate you. The object really is to punish you for inaccuracies in a resume that were not motivated by some greedy desire to get a job. She obviously promoted the experience and credentials of her colleague, not her own. And so, Your Honor, if this were as Ms. Lawless says, a more egregious case, where she's fabricating credentials and the like, but if you look at the totality of the communications, you can see she was very candid about her lack of experience. She didn't make any bones about that. So I think that if you look at the totality, rather than take a microscope to one or two sections where there are some inaccuracies, then I think, in fairness, a reprimand is more than enough. I also would say, to Your Honor's question, there are many mitigating factors in this case. Her complete candor, her youth, her inexperience, no prior disciplinary record, good faith efforts to rectify the consequences, immediately working to rectify the problems with the paperwork, her remorse, her apology. There's an allegation that she was unapologetic. That's absolutely untrue. She provided a written apology when most lawyers would have said, hey, I'm not going to get myself into liability. I don't believe this person will be back, Your Honor, before you for any discipline in the future, and I would really ask every consideration for her. Thank you.